Hello, I'm Leon Koziol, a human rights advocate who practiced law in federal and state courts for more than 23 years. I'm here today to share with you a vital public message, one that exposes an epidemic in our nation's divorce and family courts. It is an epidemic that is harming all aspects of American society today, from our healthcare institutions to the education of our children, effective law enforcement to our very productivity as a nation. We hear a lot from whistleblowers on various crises that have come from time to time across the United States. But this particular crisis is one that affects virtually all Americans, whether or not you have ever stepped into a divorce or family court. It is an epidemic that has been highly censored, one that our oversight agencies have given very little attention to, despite their vital role in protecting us from abuses of government itself. For this reason, my hope is that you will share this message with those around you. Over the next 15 to 20 minutes, I will lay out how this epidemic has come about, how it has impaired all sorts of victims, children, moms, dads, families, employers, and so forth. I will also explain how it impaired a whistleblower like me to such a severity that my life was actually put in jeopardy. And so I'll begin with one whistleblower that has been brought out in news releases in recent days. Those stories have featured Frances Haugen, a 37-year-old former products manager with Facebook. Within 2 days of her October 3rd, 2021 whistleblower interview on CBS 60 Minutes, she was treated to an exclusive hearing before a Senate subcommittee regarding the known toxic effects which Facebook and Instagram were having on teen girls. She opened with the following remarks, quote, "I am here today because I believe that Facebook products harm children, stoke division, and weaken our democracy. The company's leadership knows how to make Facebook and Instagram safer, but won't make the necessary changes because they have put their astronomical profits before people. Congressional action is needed. They won't solve this crisis without your help," end quote. Ms. Haugen went on to state that she came forward at, quote, "great personal risk," end quote, because she believes that there's still time to act, but she did not disclose what those risks were or how she was impaired in any way. I am here to reiterate my ordeal as a corruption-fighting whistleblower, a genuine one who suffered horrific retributions over an extended period. It cost me my law practice, stellar reputation as an accomplished civil rights attorney, all contact with my teen daughters, and ultimately a near-death experience that landed me in the hospital this past year. All this continues to be concealed from public accountability. My disclosures verify a growing crisis, one that exceeds the Facebook impacts exposed by Ms. Haugen. It is one that parents have faced in our nation's divorce and family courts for decades. The retaliation against me escalated when I threatened the money trail, how federal Title 4D funds were being abused to the tune of billions of dollars in these courts. It caused irreparable harm to my own teen daughters. On September 23rd, 2021, after submitting whistleblower reports to authorities and sponsoring a 3-day event at our nation's capital, I testified before a blue ribbon commission of New York Governor Kathy Hochul. It was focused on forensic evaluations in the state's courts. I disclosed how such evaluations were being needlessly ordered to advance the profit interests of lawyers and service providers. I also disclosed how they were being exploited to harm my credibility while inciting child murders, domestic violence, parent suicides, and even a father so traumatized that he burned himself alive on the steps of a family court building. None of this seemed to faze our representatives in government, as lip service and deflection became the routine. I was therefore compelled to distill the corruption into a newly published book entitled Whistleblower in Paris. It draws upon my experience as a trial attorney, public office holder, and model parent. This book was presented to the Commission due to a silent epidemic that could not logistically be presented within the parameters of any public hearing. Unfortunately, as my post-hearing submission now asserts, this commission is taking on the character of the Moreland Commission on Public Corruption, which Governor Hochul's predecessor, Andrew Cuomo, created in 2013 to address a, quote, culture of corruption in Albany, end quote. I testified as well before that commission, but it was prematurely dissolved when evidence became very damning. Fortunately, one of the speakers, a federal prosecutor, seized commission files, resulting in prison terms for the leaders of New York's legislature and a top Cuomo aide. The recent Blue Ribbon hearing was conducted virtually and haphazardly. Some presenters appeared from vehicles or sloppily dressed from home, with full video and screen identities. Others, like me, were publicized by voice only, with no indication of how diverse testimony would be considered by members of this commission. Indications today are that this entire process constitutes more window dressing theater with no real promise of reform. This sham production is particularly injurious to whistleblowers who sacrifice dearly to secure such reform. Because our courts are self-regulated and held to a higher level of respect than the other two branches, qualified attorneys like me are easily targeted, discredited, and punished in violation of our most fundamental rights under the Constitution. Indeed, as the public servants charged with the greatest duty of upholding these rights, judges are instead abusing their trust to cover up this corruption. And, like Facebook, it is being done to advance astronomical profits. To offset the rapid-fire assault upon my credibility, it became necessary to cite achievements as a lawyer which cannot be erased. Over the years, I took on prominent David Goliath challenges against some of the most influential law firms in America. For example, I secured final judgment in New York Supreme Court which invalidated a billion-dollar casino compact on constitutional grounds, a federal civil rights verdict that invalidated a city gag order, a restraining order on a $30 million school project right out of law school, and numerous civil rights recoveries. Today, I am unable to get a family court judge to arrange simple phone contact with my own daughters. My successes are verified by features on 60 Minutes, front page of the New York Times, and other prominent news mediums. Such publications yielded powerful adversaries anxious to join any witch hunt that could end my capacity to obtain similar justice for countless victims of government abuse. Today, my law licenses remain suspended for over 11 years without any disbarment, criminal conviction, or legal malpractice. The persecution is unlike any other in the history of the New York Bar, of which I remain a dues-obligated member. With this backdrop, I would like to reference aspects of my book due to this unprecedented nature. In Chapter 13, entitled Show Trials in the Gold Mine, I disclose how 40 trial jurists were removed from my originally uncontested divorce. Half properly disqualified themselves due to my high-profile activity in our judicial district after a venue change was wrongly denied. Then, I explained how a group of them acted in tandem to orchestrate grounds for child support incarceration, which forced me to seek asylum in Paris. I labeled them the Sadistic Seven, after they nearly ended my life. They did not do it directly, but recklessly, through unchecked misconduct that predictably yielded a toxic environment, much like a drunk driver does on our highways. The abuse of forensic authority began in 2010 during a series of news stories regarding my license suspensions and conscientious stand against my profession. The retaliation upon such whistleblowing was made easier by my faithful status as attorney and parent litigating simultaneously in a dysfunctional court system. Even my secretary was influenced to commit crimes and ethics violations in my office. She was eventually committed to jail, but only for crimes upon later law office employers. Here is a relevant excerpt from page 71 of my book. Unfortunately, not only was the systemic retaliation and internal crimes complicated, but I was also made subject to an antiquated 11 trial court structure in the underlying litigation. It yielded off-the-charts chaos. This is not a self-serving claim, but a serious dysfunction backed by a 2017 state bar report that compared New York's structure to the single trial court of our largest state of California, having twice the population. That report was generated to promote reform at a constitutional convention rejected by voters after vigorous union opposition. One excerpt is highly relevant here, and I quote, "Whether New Yorkers are seeking a divorce and child support, challenging a speeding ticket, resolving a business dispute, or serving on a jury, they must negotiate a complex and baffling state court system. It is so complicated that Article 6 of the state constitution requires more than 15,000 words to describe it. In contrast, the judiciary article of the U.S. Constitution is only 375 words. It, New York Constitution, is a 52,500 word behemoth filled with minutia and obsolete provisions, and even sections that the U.S. Supreme Court has declared unconstitutional. The abuse in my case is ongoing, without any finding of unfit parenting, no complaint to any child protection agency, and tactical offense petitions that were all thrown out. It is further corroborated by the sadistic filing of a support violation petition during my hospital stay in January of this year. This all gets unimaginable when my own daughters refused to check up on me despite my dire condition at the time. My ordeal will verify how these forensic orders were abused to inflict the most severe form of parental alienation, while a blind eye was turned to the false accusations. Although my right to a defense and recourse for such accusations were twisted into an abusive process, the reality is that the parent alienator here was given free rein to commit an atrocity. She could not have done this alone and was never even cautioned. Discrimination this severe can lead to all sorts of fatal outcomes. And when our justice system breaks down, the Constitution confers a right upon its victims to take the law into our own hands. Yet, as my book concludes, I was able to exercise remarkable restraint that was more commendable than my accomplishments. How serious was the retaliation? And if it can occur to me, what does this mean for the unsuspecting litigant? A brief synopsis of the sadistic seven, as I called them, may help answer such questions on audacity alone. In 2011, Family Judge Michelle Pirro-Bailey in Syracuse issued the first forensic evaluation of both parties in my ever-complicating case. She did so in my absence, after I obtained permission to exit proceedings based on her admitted failure to read my submissions and later refusal to hear oral argument. This constituted a clear violation of due process and judicial ethics. She disqualified herself days later without explanation and was replaced by Family Judge Bryan Hedges, who refused to disturb her forensic order. He then granted my motion for his removal before admitting to sexual abuse of his handicapped 5-year-old niece. It forced his resignation and a permanent ban from judicial office by the High Court of New York. Judge Michael Hanusak was then assigned. He promptly removed this forensic order on the same record, without even a hearing, thereby demonstrating how whimsical these evaluations truly are. Costly appellate review is limited to, quote-unquote, sound discretion, which can mean anything. This judge was later forced to resign after the Judicial Commission found that he had sexually harassed his court clerks. In my reports and website postings, I lobbied for a judicial policy which required psychiatric evaluations for judges, not unlike those imposed on litigants and law enforcement. Judge Daniel King was a newly elected family judge in Lewis County who replaced Judge Hanusak in 2013. During his tenure, I gave testimony before the Moreland Commission, which exposed fabricated college degrees he used to aggravate my support obligations. In retaliation, only weeks later, Judge King issued a battery of forensic orders exclusively upon me, which could not be satisfied logistically or financially after my reputation, automobiles, business accounts, and professional licenses were seized for support violations. These orders were based on such concoctions as, get ready for this, a, quote, alcohol-related gesture, end quote, a champagne toast at my niece's wedding. As incredulous as this is, it can be found on page 5 of a December 2nd, 2013 decision, which was quickly halted on appeal. But the forensic orders were reinstated the next month during a custody trial, which I also exited early due to Judge King's directive to cease making objections to the defamatory narratives of an unrepresented adversary. The evident objective here was to orchestrate a damning record to support the earlier bizarre impositions. Judge King disqualified himself 2 years later after I challenged his gag order on my website. So overbroad, it even prohibited a strangulation of my own daughters. This is about the time that Facebook reactions to that website dropped from over 2,000 shares to only a few today. Judge James Eby of Oswego Family Court replaced Judge King. His first order of business was to require the parties to make a 160-mile round trip to receive a decision that had already been completed. Unlike Judge Hanasak, he refused to remove the unsatisfied forensic orders that were now 3 years old. His childish antics caused another 2 years of parental alienation. Gerald Popeo was then assigned as judge number 40 out of Utica City Court, contrary to logic. He was bent on revenge for a public censure issued against him by a judicial commission for making racist remarks and physical threats from the bench. He took advantage of the stale forensic orders by siding with his security guard and support magistrate, displayed a clear showing that they had together violated due process. This presumably caused Judge Eby to step down earlier, but due to the protected nature of this assignment process, we may never know. Both judges are no longer on the bench, but Popeo's peculiar assignment led to a secret bulletin attached to a support warrant, which a traffic cop declared sufficient to shoot me on sight. Such bulletins and interpretations would not have issued had the target been a woman. A key example is the treatment of Florida Judge Jerry Collins in a domestic violence case. At page 140 of my book, in a chapter entitled Gender Skirmish, I relate this incident to a fugitive mom that I met in Paris. I will read it here. Take, for example, that recent case about a mother who filed a domestic violence charge. She never even showed up in court for her own trial. The judge, a woman by the way, held her in contempt and hit her with a 3-day jail term. That was a small penalty when you compare it to 6 months for child support contempt, typically doled out to male violators. Now, how do you operate a court system if filers can do a hit and run like that? Women's groups went ballistic anyway. They protested that judge for being so harsh, and it got all kinds of media coverage. Never mind this kind of harshness is going on all the time with guy victims, or that allegations are not proof. The charge alone was career damaging, with huge defense costs. But the accused here just didn't matter. Neither did his due process rights. That judge was actually reprimanded for her conduct by the Florida Supreme Court. We need more bad moms in jail to equal the playing field here. Quite beyond the gender bias, any targeted speech aggravated the relentless assaults. At page 17, I describe it as follows. My ordeal was needlessly complicated for revenge and then blamed on me to scare away public oversight. Crafty jurists would use the terms such as rambling and incomprehensible to derail my logical arguments against a lucrative custody institution that was creating monsters among our offspring and crimes of unimaginable proportion. Remarkably, the intellectual guardians of our First Amendment marched over my logic like zombies in an Independence Day parade. Simply put, judges were abusing their powers to kill a reform message that applied to their own misconduct, while approving large-scale verdicts for civil rights victims against employers and law enforcement. They were using their own guns to kill a similar victim. I likened it to a Rodney King beating, with the fists and batons replaced by orders and edicts, a hypocrisy of monumental proportion. They twisted every fact and precedent and the light most damaging to the public critic. This represents a very brief synopsis of a human rights ordeal that shocks the conscience. It is reflective of a greater crisis, a silent epidemic that is scaring away oversight. Because it features violations common to other cases across the country, mine is ideal for an investigation by the Justice Department and hearings in Congress to review Title IV defunding abuses in these courts. It should not require another fatality or prominent figure to trigger overdue reform. Alec Baldwin is one who dutifully complied with the evaluation orders in the courts of California, only to find himself an ultimate victim. His suicide words have long been forgotten, but quoting from page 183 of his own book in 2008, entitled A Promise to Ourselves, I have reproduced those words here. And I'm quoting from Alec Baldwin. My family and closest friends were still there for me, but even some of them had grown perplexed and very weary of the assault upon my parental rights that seemed to have no end. On the deepest level, my situation now seemed hopeless to me as well. I had gone to sleep many nights doubting that I had the desire to face these problems another day. Driving up the Taconic Parkway, heading to an inn in the Berkshire Mountains, I began to think about what little-known town I would repair to in order to commit suicide. What semi-remote Massachusetts state park could I hike deep into and shoot myself? What bed and breakfast could I check into and overdose there? On Long Island, I thought about the old Jeep I owned and the emissions it gave off. When I returned to New York, the thought of jumping out the window of my apartment was with me every night for weeks. Yes, the corruption in our divorce and family courts is serious and ongoing. Its harm to innocent children and families is immeasurable, with no genuine interest by our government to correct it. Indeed, the Blue Ribbon hearing sponsor was identified as the New York Office for the Prevention of Domestic Violence. On at least one posting, its taxpayer-financed efforts were directed to protecting women and girls, with only lip service given to the other half of the human population victimized by false charges that destroy a man's career and ability to support his own girls. How does such a gender-aligned agency become an overseer of forensic study by an expert panel? And what trust can male contributors give to this process? At one time, the civil rights agenda I joined was intended to advocate for equal rights. Today, it's women's rights. False accusations were treated as a form of domestic violence. Today, such perjury has incurred a disappearing act in both our courts and enforcement agencies. At what point, then, do competing rights collide to incite a gender war or a lucrative divorce of American society itself? These are questions brewing as part of a silent epidemic exposed by a qualified whistleblower. It warrants a federal investigation of human rights violations and funding abuses in these courts because, once again, our state counterparts have failed us in their governing duties. All civic-minded people are now called upon to demand this for the benefit of future generations of America. I want to thank you for listening to this vital public message and wishing you a good day. Thank you.